I am for the respondent number 11.
But I am for the petition.
We mentioned 11.
I have the copy of it, sir. Sir.
We mentioned again. Oh,
I'm appearing for the state, my lord. On the earlier occasion, this matter has been released by Honorable Justice Amrita Sinha. My lord, I submitted all reports on in that record, my lord, on the earlier occasion.
the cost title and the presentation form has to be changed.
For Roman Gaji and first title.
Presentation form and the cost title has to be changed. Classification
Under
form.
different group, my lord. Grateful, my lord.
Classification is group 5, my lord. Still group 5.
So what have you written in the presentation form? Just have a look to this. Now this has to be corrected. Thereafter, this can be placed for. This matter is appearing under the heading to be mentioned. On the prayer of learned advocate for the petitioner, leave is granted to correct the presentation form. And the cause title. Mentioning the classification under group 5. Likhi din record. Record din. What is this case?
The Panchayat.
What is your...
The absolute owner. Private responded, my lord, without taking any sanction plan, without taking any permission from the Panchayat, he has been constructed 3-story building. Already building. And matter was moved before the Honorable Justice Rajsekhar Manta. Kindly see the order. Page. Page 29.
Hearing it, returnable motion. State has filed its report.
My lord, on the earlier occasion, we have already submitted reports before Honorable Justice Amrita Sinha's court.
Returnable motion. Leave is granted correct. List this matter under the heading. Returnable motion on. Matter. Next week.
My lord, state presence to be noted, my lord.
Uh, 21st. 21st returnable motion. In the meantime, you correct the cause title and the presentation form.
My lord, kindly serve with the correct representation form and presentation, my lord. Kindly direct the petitioner.
Yes, what is it? It is a formal correction. Again, he will serve copy.
My lord, just the first presentation and representation.
Petition directed to serve a copy of the corrected presentation form and the cause title upon the learned advocate for the state respondents.
My lord, kindly record a presence, my lord.
All recorded.
Grateful, my lord. Gratefully, your lordship.
Yes. $43. Only 43. Oh. Your convenience join seeks to make his replies.
I will be very brief in my reply. Well, I will teach your lordship. Subject to correction by my learned friend. On the last occasion, Mr. Bose, appearing for Haldia Development Authority, had submitted that the letter, that is the allotment letter dated September 11, 2001,
Hmm.
was the offer, and our reply dated September 13, 2001 is the counter offer. Subject to correction by my learned friend. I will stand corrected. If I am wrong, I stand corrected. Now, my lord, this is very vital, my lord. Kindly take September 11, 2001, which your lordship will find at page 37. This is the address. I'm sorry, my lord. My lord has got that. May I take your lordship quickly through this letter? Offer of land measuring 50 acres for setting up of an aluminium and steel-based industry. Your letter dated so and so. With reference to the above, we are pleased to provisionally offer you 50 acres of land at Mouza so and so, PS Shutahata, District Midnapur. As regards allotment of land, the following terms may be please noted. So, this is the these are the terms and condition. Kindly take condition number 2. That is the land premium rate is 5.5 lakhs per acre. I'm sorry, per acre, and token rent at the rate of 0.25% of the total land premium per year will have to be paid, which will be enhanced at 5% annually, subject to approval of Board of Haldia Development Authority. So, these were the terms and conditions. Now, we immediately wrote a letter. Kindly take our letter, which is at page 39, which according to HDA is our counter offer. We have, my lord has got that. This dated September 13, 2001. That is 2 days later. We have for thankful acknowledgement your offer letter number so and so dated 11/9/2001. We have noted the terms and conditions you have stipulated to which we are agreeable. However, we find that the land premium rate is of rupees 5.5 lakhs per acre is quite high compared to our earlier estimate, and we will just not be able to bear this hefty amount. We ardently request you to kindly reconsider the premium rate and reduce it to an amount within our means. You will appreciate that the proposed land of 50 acres is very low lying and an enormous amount of funds will be required for land filling and development. So this according to Mr. Bose, that is HDA, our counter offer. Now, Miller, comes the board resolution, which your lordship will kindly take page 40. This is the 71st board meeting of HDA.
Yes. Yes.
And if your lordship kindly takes page 41. May I read out? 71.35. Land premium for Messrs. Hindustan Seals Limited. That is our predecessor in interest. Following an application of Messrs. Hindustan Seals for allotment of 50 acres of land, preferably on the bank of river for setting up of an aluminium and steel-based industry, a provisional offer letter was issued in favor of them for 50 acres of land as per usual terms and conditions, as per which the land premium is rupees 5.5 lakh per acre for the first 50 acres. The recently Messrs. Hindustan Seals, vide their letter dated September 13, 2001, has requested we find that the land premium rate of rupees 5.5 lakh per acre is quite high compared to our earlier estimate, and we will just not be able to bear this hefty amount. We ardently request you to kindly reconsider the premium rate and reduce it to an amount within our means. You will appreciate that the proposed land of 50 acres is very low lying and an enormous amount of funds will be required for land filling and development. Board may kindly peruse and decide. Now the resolution. Board resolved that in view of the fact that this is extremely crucial, this holds the key to this entire issue. The board resolved that in view of the fact that construction of infrastructure such as approach road, water supply and availability of power line up to the factory gate involves huge cost, it is not possible to reduce the land premium rate. So, on a conjoint reading of the offer letter dated September 11, 2001, our counter offer of September 13, 2001, and the 71st board meeting resolution, it would be apparent that this amount, this land premium rate of 5.5 lakh per acre was inclusive of the cost of infrastructure. And this is the key to this matter. So the offer of 5.5 lakh per acre is the sum per acre which is to be paid by the intending lessee, and this sum includes the cost of infrastructure. Admittedly,
But this was not mentioned in the offer letter.
this was not mentioned in the offer letter. When we made the counter offer, they justified that why are we charging? We are charging you 5.5 lakhs per acre because we have to get the infrastructure ready for you. So obviously, this amount of 5.5 lakh per acre was inclusive of the cost of infrastructure development. This is the ID cost, as we say.
Okay.
And it is nobody's case. It is not the case of the petitioner that they will not pay 5.5 lakh per acre. As and when there was a gradually, this infrastructure was, there was enormous delay. In my notes, I will indicate enormous delay. Several board resolutions would indicate that they failed and repeatedly failed to get the infrastructure ready within time. As a result whereof, the commencement of commercial production also got delayed. We are running a business, it's a commercial production in a unit, industrial unit. So, whatever 5.5 lakhs we have to pay, unless and until they get the infrastructure ready, admittedly that is inclusive in that 5.5 lakh per acre, why would we pay? And then, when it came to 2008, they started writing letters. Now I will charge you 15 lakhs per acre because there has been a delay on your part. Those two notices of February 2008 and 4th July 2008 are the subject matter of challenge in the real petition. In my notes, I will indicate, what are the correspondence, what are the board resolution. We have taken your lordship through that. The list of dates we had already submitted.
Yeah. How goes that?
Right. Yes, the submission which was made on behalf of HDA, that our offer or we did not make any commitment. HDA says that the HDA did not make any commitment to provide to get the infrastructure ready for the project. This board resolution, is a clear proof of the fact that the board was committed to get the infrastructure ready. And 5.5 lakhs, I am on the consideration part. That's the, these are commercial matters. The commercial matters has to be viewed commercially. 5.5 acres is the land premium. We say you reduce it. They do not accept my counter offer. Well and good. What was the condition? Look, I have to get the infrastructure ready. That is why I am charging you this amount. And this is how the lease was entered into for 15 acres. This deed was executed. For the balance 35 acres, lease deed was not executed. In fact, they accepted 50% of the total amount from us. That is about 1.27 crores. Correct? Subsequent to the receipt of 50% of the total amount, the HDA executed lease deed only for 15 acres.
Yes.
Then, we paid another 41.25 crores. 41.25 lakhs, I'm sorry. 41.25 lakhs. Then, my lord, when we offered to pay the balance, my lord, 96.25 lakhs, they declined to accept our payment and they said now that you have to pay at the current market value. That is 15 lakhs. That is the subject matter of challenge. Now, my lord, interestingly, when we moved this honorable court, my lord, there was an interim order passed by this honorable court that you, without prejudice to your rights, you pay 96.25 lakhs and they will not evict you from the balance 35 acres of land. My lord, we paid that 96.25 lakhs pursuant to the direction given by your lordship. They accepted that amount. When was this payment made? In 2008. We are in 2025. Was any appeal preferred against that interim order? I put the question to myself with all humility. Answer would be in the negative. No. Now, my lord, interestingly, till, my lord, this decision to enhance the land premium to 15 lakhs per acre, HDA continued to accept rent for entire 50 acres. At what rate? At the rate of 0.25% of the land premium value. And what that is the original offer letter. Lordship will find from the original offer letter. Kindly take the original offer letter, which is at page, this is so important, 37. Kindly take, my lord, this is so important. Clause 2. Once again, I trouble your lordship with clause 2.
Yes.
Land premium rate is 5.5 lakhs per acre and token rent of 0.25% of the total land premium per year will have to be paid, which will be enhanced at 5% per annually, subject to approval of board of 5%. বুঝতে পারছি না হ্যাঁ মানে subject to the approval of board of Haldia Development Authority. So, 0.25% was paid of the total land premium amount. What is the land premium amount? The land premium amount would mean the land premium amount of rupees 2.54 crores, which is, my lord, the total land premium amount for 50 acres of land. This fact, when disclosed in our affidavit in reply, in the supplementary affidavit in opposition, they said that does not confer any right upon you. We may have accepted that. Specific pleading is there. So, my lord, what is the consequence is that first, my lord, there was an offer. We made a counter offer rejected. They say that I'm going to charge you 5.5 lakhs per acre for the infrastructure. The cost is the land premium rate is inclusive of the cost of infrastructure. They do not get the land infrastructure ready within time. Several board resolutions are there. I'm not traveling at the stage of reply. I'm already there in the notes. I will file my notes. Kindly give me. By Tuesday, I will file my notes. And then, my lord, what happened? Then we continued to make payment of rent for the entire 50 acres.
Yes.
And then, lastly, my lord, they issue a notice. First, enhancement notice, then termination notice, then eviction notice. This is the sum and substance of the entire matter. We will file our written notes.
I am ready with, my written notes of argument, since my learned senior friend has, raised certain points, elaborating or elucidating, his earliest stand, these 2 points, I need to deal with. I am ready, otherwise I am armed with this. So I will also file, my written notes of argument on Tuesday.
So you have concluded, Mr. Majumdar?
Yes.
Majumdar, senior advocate appearing for the petitioner, concludes his replies. He seeks to file written notes of argument. Mr. Kollol Basu, learned advocate appearing for the respondent numbers 2 and 3, Haldia Development Authority, also seeks to file written notes of argument.
Grateful
Okay.
for your lordship's kind.
Okay. Thank you.
Yes, deeply obliged.
Just submitting our notes on Tuesday.
Okay, Tuesday we find out date of birth.
Yes, I will also. Yes, deeply obliged.
Process notices are ready.
It is ready, but he will incorporate something which you have submitted.
Yes. Because
Yes,
I
and
have to deal with this.
Tuesday কি তারিখ হচ্ছে দেখো?
I will try that.
Okay. কবে হচ্ছে?
20th.
20th. 20th. Yes. So, না, যেরকম থাকে 2 p.m. Application.
I'm saying for not this big one.
Why? What is this application?
Subject matter is the challenge of the order of the
application for the
Oh, application.
No application has been solved.
আমাকে তো কোনো
Since February, you have not served the application.
আরে স্টেটকেই তো তুমি দাওনি।
Application needs to be solved. We are not solved. Completes a substitution application.
Okay. Ashun. Learned advocate, you are first. Respondent. Learned advocate for the respondent Nadia Jila Parishad submits that the copy of the application has not been served. State, Mr. Mahathir, you have been served?
No.
Learned advocate, Mr. Mahatha, learned advocate, Lalit Mohan Mahatha, learned additional government period also submits that copy of the application has not been served. ওগুলো বোধকে একসাথেই করে দিন উপরে একই কথা তো It is directed to serve copy of this application upon the state respondents as well as respondent Nadia Jila Parishad and file affidavit of service on the returnable date. Is this matter? শেষের দিকে রাখ 20 তারিখ 21 তারিখে 21st. Affidavit of service.
Private respondent book of this upload people upload moving update. Application they should upload keep notice, but we have not. However, Lord, I am from the private respondent. 8 and 9.
Pradhan has been served.
Zero.
7116 71 delivered. Yes. What is this case?
Petitioner is a senior citizen. She has land of crop land in the scheduled land, and it is classified as JOL. All of a sudden, private respondent has encroached the land by filling up various types of soils, rocks, etc., and has constructed an illegal building, which has been already encroached some portion of the land of my petitioner, due to which egress and ingress have been already stopped. Several times she has requested to at least allow her to get the entry, but she is they have denied, and already one GD has been entered in the local police station on 29th June 2024. Petitioner has submitted her prayer, page number 20, annexure P5, before the Panchayat authority for demolition of said illegal construction under the provision of West Bengal Panchayat Act 1973.
Yes.
But till date, the Panchayat authority has not been responded.
What is the DAG number?
Tag number, Milot, schedule has been mentioned. Tag number 425
jail number 97, Mouja, Brindabanpur, under Chondipur police station, and classified as Jal. Area is 0.24 acre.
Which one?
Page number ROR is already annexed, my lord.
P1. Which one?
Page 15 is the ROR. Gauri Rani Das, petitioner.
Oh. There are other co-sharers.
Yes, my lord. But there is a different Khotian number, and there is previously there was no dispute in this land because it is agricultural land. All of a sudden they have filled this land and constructed this illegal building.
Yes.
Lord, Mr. Milord, he has applied before the Milord Gram Panchayat, Pradhan. What is his Milord contention? They said that I have enclosed his land. For encroachment, can the Pradhan Milord can decide the matter?
Not
Can-
only the
can the
illegal
Milord-
construction has been made.
Lord, he has said that I was residing out yes, Lord, long distance from the plot. Now the petitioner, the respondent has Lord suddenly enclosed his Lord land and he has constructed. Lord, kindly see the Lord representation Lord page 20. Lord, I, Gauri Rani Das of the above address, would like to inform you that I am the owner and occupier of above land by virtue of deed gift. But the neighbors of the said plot belonging to same family, all of a sudden, same family, Lord, these are Lord
You are adjoining.
adjoining Lord, same family and Lord, same plot of land. Lord, all on a sudden, opposite parties here above has constructed an illegal house unauthorizedly, obstructing my ingress and egress. I have already complained to the local authority police station, GD number such and such, against the illegal construction encroachment by the opposite party. Lord, his Lord,
Construction
Objection.
is illegal. There is no permission from the Panchayat authority, and
Lord,
there,
Lord, I
there
have
is
got,
no
I have,
question
I
of
have got
construction
instruction that
because
I
it is Jala
have
land.
got permission. I have got instruction. I have got permission with the Panchayat, Lord. I have constructing the Lord, constructing the Lord Paka building, Lord, whatever it may be. But his Lord, his prayer is, I have enclosed his land. Lord, in paragraph also he has stated 5. Can the Pradhan Lord decide the same? The encroachment. This is
Illegal construction can be decided.
civil dispute.
They are for demolition. my lord,
It is a civil dispute. Whether the if the demarcation is not ascertained, if the line of the plot is not ascertained, he is saying here I have enclosed. I am saying I am on the in my land.
my lord,
Then
this
who will
is-
decide?
This is
This is a
Jala
civil
land.
dispute.
There is no question of construction. So Panchayat authority
Lord,
cannot.
because I
give any
I have got
permission. There is
conversion.
there is no-
I have
no
got conversion. I have got conversion.
There is no permission for this building construction.
I have got
No
conversion.
sanction plan.
Conversion, Lord.
Panchayat authority has not been sanctioned any construction plan in this area.
Lord, I have got conversion. With me. In 2013, I have got conversion.
There is no sanction plan of construction.
Sanction plan.
Lord, that is not, Lord, I have told that it was with them, but they have now, Lord, they are not getting the same, but it was misplaced perhaps. But they are trying to give, Lord, get the certificate copy from the Lord authority concerned, Lord, that is not with them. I have got, Lord. Instruction.
Concerned authority and PLR already inspected. They have also agreed that it is dollar.
Let the sanction plan be produced by him. Affidavit of service filed on behalf of the petitioner is taken on record. Mr. So-and-so, learned advocate for the petitioner, contains that the
I am submitting, Lord. Kindly see your lordship died them, Lord. If the authority has not, Lord, granted or not, the Pradhan is the authority to decide the same. Let the Pradhan decide. He has, Lord, made depends on the Gram Pradhan.
Before the PLRO is
Let me decided by the Pradhan.
for conversion related issue, PLRO also need
Because
to submit
the records are lying with his office.
I rented the
in the office of the Pradhan.
Pradhan.
The Pradhan will decide the
My
if
lord,
there is
then
illegality.
I have not, then I have nothing to say.
Why?
His grievance is same. But my submission was that is civil in nature. Your lordship may direct the Pradhan to Lord decide the same.
State, which for the state, you may appear for. Anybody from the panel gives? Mr. So-and-so read the petitioner. This writ petition, this writ petition fine seeking for demolition of unauthorized construction undertaken by the private respondents over the land of the petitioner comprised in Dag number 425, jail number 097 in Mauja, Vrindavanpur, under police station Chondipur, measuring more or less 0.24 acres under district Purbo Mednipur, and for consideration of representation of the petitioner dated 10th August 2024 within bracket annexure P5. The writ petitioner contains that the private respondents have undertaken unauthorized construction over the property in question, illegally obstructing the ingress and egress of the petitioner. Representation was on 10th August 2024. Representation was made before the concerned authority, but
Kindly, Lord,
no step has been taken.
my record, my submission be recorded. They have, Lord.
No. Mr. So-and-so, learned advocate for the petitioner, submits. Hence, this writ petition. No steps has been taken. Hence, this learned advocate for the petitioner submits that the respondent number 4, Pradhan Vrindavanpur 1 Gram Panchayat, be directed to consider the representation of the petitioner. Mr. So-and-so, learned advocate for the private respondent, submits that the work of construction has been undertaken in terms of as per the sanctioned building plan and upon conversion of the classification of the land. However, he submits that the matter may be relegated to Pradhan. The matter, the dispute is civil in nature. However, he submits that the matter in dispute be relegated to the Pradhan to cause inquiry and pass necessary orders. None appears on behalf of the state. Who will appear for the state? Is there anybody? Mr. Mahatha is appearing in all the cases. Is there anybody from the state panel? You appear. Mr. So-and-so, learned advocate, who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. So-and-so be regularized by the concerned authority. Petition is directed to serve a copy of this writ petition as well as its annexures to Mr. So-and-so, learned advocate for the state. Para, learned advocate for the state, also submits for relegating the matter to the Pradhan. Upon consideration, clauses it is made clear that since no affidavit has been called for, the allegations made in the writ petition is deemed to be not admitted. This court has not gone into the merits of the writ petition. Within 2 months, inquiry will be caused. Thereafter, he will pass necessary order. Disposed of.
copy has been handed over to the state. Grateful.
Service has been Act of PC, the year 2010, Jela Parishad at an advertisement directly directing the candidate applied for recruit a homeopathy doctor in this several companies. Petitioners applied for and participated in the interview, and they stood first in the panel, and they are going to another in earlier occasion. One petition was filed. Thereafter, that application was withdrawn as because Jela Parishad asked the client, the petitioner, until and unless matter is pending, we cannot decide anything. Thereafter, they have not decided. One of the candidates, they filed a petition, and that is your lordship can see. Honorable Judge Compass Sarkar at page 64. Thereafter, authority
Yes.
thereafter authority concern consider the petition at page 68. Half an hour.
Yes.
Thereafter, your lordship will see the supplementary evidence which I have.
Yes.
Page 5 and last portion, last 3 lines from the bottom. You may either be panel of doctor pending deal with dispensaries are sanctioned by Health and Family Welfare Department under the budgetary support or cancel the ban. Well, they say dispensary is still going on, running, and these petitioners they are working with a low remuneration. That has not yet been properly considered. That's why your lordship kindly, if your lordship kindly sends the matter to the principal secretary and consider the same.
But then if the fund is not sanctioned by the department, approval is not there from the department, how can the department be liable? What is the liability of the department?
Why not? Your lordship
As per they have quoted a notification that for running the guidelines,
Here my lord, your lordship page again annexure P10.
P10 of supplementary.
No, then page 71. Then the Rural Development Department issued a notice on 19/7/2023
section of Gram Panchayat for engagement of part-time contractual medical officer under state budget and head category. But they are all the Ayush doctor. But they are still working from 2010.
What do you want?
So you will not be kindly send the matter to the principal secretary so that he is the appropriate authority to take a decision regarding this sanction or consider their.
But then they cannot be absorbed in respect of the notification dated 19 July 2023 of the Panchayat. Because they were earlier, they were appointed as per the notification of the Jila Parishad.
That the recruitment has not yet been given, my lord. 19/7, 2023.
Hmm.
That appointment
Yes,
has not yet been given.
Even if it is not given, but that is not as per the formal approval of the Panchayat. Otherwise, the Panchayat would have been responsible.
Yeah.
Correct. But that will be escalation of something which is. There are such government. They say that formal approval was necessary. That has not been taken. It is also admitted by you. Then
If your lordship pass this order, then my lord, my landlord has no objection.
but he has not submitted. He has not submitted as yet.
He has no
My lord, already their decision has been taken by the joint secretary. Joint secretary has taken the decision unless there is approval from the government. My lord, this scheme cannot be implemented. Joint secretary has already passed. Joint secretary, that means, my lord, at the instruction of the
15 years, my lord, they are working, my lord.
joint secretary to the government of West Bengal Panchayat and Rural Development has passed the order, my lord. And referring all the relevant circulars. And my lord, originally if anything is there, that is from the Jila Parishad. Now Jila Parishad also, my lord, shut up their hand.
Or your lordship can direct Jila Parishad, my lord, they take
Even unless it has been approved by the government, Jila Parishad is nothing to say.
But they are getting remuneration from the Panchayat.
Panchayat, that is from their contingency fund.
But then is there any fund of the government where the Panchayat can apply to have a
It is not the government fund. There is contingency fund, means there is some certain fund which is collected from the tax of the taxpayers, and the Panchayat kept it separately, yearly 25,000 or 30,000. It may be now 50,000. That can they expend of it their its exigency. This is your sometime there is electricity disturbance or anything. There are some many emergency cases. The Panchayat has the power to expend that fund. That is contingency fund. That is not the government fund. That is not the audited fund. Government audited fund not.
Very key. Then there is no relief for Mr. Banerjee. What to do? Affidavit of service filed on behalf of the petition is taken on record. This writ petition is filed challenging the order directing the responding authorities to give appointment to the petitioners as per the interview held pertaining to the notification dated 7th August 2009 prepared by the authority, Annexure P6 to the writ petition. The petitioners contends that content that on 7th August 2009, Paschim Medinipur Jila Parishad issued a letter to all Panchayat Samitis and Gram Panchayats to display notice for recruitment of homeopathy doctor in respective panchayats. Having qualification of BHMS and DMS. The petitioners applied before the authority, and on the basis of the applications, they were directed to appear for an interview process. And the petitioners were selected. Since no appointment was given to the petitioners, they filed a writ petition being WP number 5519 of 2011. In the aforesaid writ petition, direction was issued upon respondent number 2 to decide the matter of the petitioners. By an order dated the pursuant to order passed by Justice Sarkar, which is the order passed?
I page 64. Second writ petition. This writ petition, first writ petition. 2011,
Oh.
this is the first writ petition. That writ petition was withdrawn.
Acha, we agate withdrawn. Subsequently, one Sajol Ghosh filed a writ petition being WP number 1303 of 2018.
Yes.
By an order dated 20th February 2019, the writ petition was disposed of with the following direction. এটা এখানে click করো। Pursuant thereto, the additional chief secretary to Government of West Bengal Panchayat and Rural Development Department has passed order here that the engagement of Dr. Sajul Kumar Ghosh is a petitioner here. Dr. Sajul Kumar Ghosh was not done in accordance with the norms, and therefore a regularization of his service at Golar Gram Panchayat as homeopathy medical officer under Keshpur block, Paschim Medinipur district is not tenable at all. And it was dismissed. Hence this writ petition is filed by the petitioners including Dr. Sajul Kumar Ghosh. It is a petition number 6, bracket दिया था. Mr. Gautam Banerjee, learned advocate for the petitioner, submits that the petitioners are discharging their function as homeopathy medical practitioner in different panchayats under Paschim Medinipur Jila Parishad for the last 15 years. They are continuing to discharge such functions at a nominal remuneration. Where is your representation?
That representation is not made.
However, they have not been regularized as yet. He seeks for appropriate direction upon the respondent authorities to consider the case of the petitioners for regularization of their engagement in the different panchayats. On the On the contrary, Mr. Lalit Mohan Mahata, learned advocate, learned additional government pleader appearing on behalf of the state, submits that prior to engagement of the petitioners as homeopathy medical practitioners, no formal approval either from the Health and Family Welfare Department or Panchayat and Rural Department was taken. And therefore, the question of regularizing the appointment of the petitioners as homeopathy medical practitioners at different Gram Panchayats under Paschim Medinipur Jila Parishad cannot arise at all. He files report which is taken on record. Learned advocate
By the Jila Parishad, not by the state.
learned advocate representing the Jila Parishad, Paschim Medinipur Jila Parishad, also submits in the similar fashion and he files a report which is taken on record. Report of Deputy Secretary Paschim Medinipur Jila Parishad dated 5th February 2024 which is taken on record. Para. The regularization of Dr. Sajul Kumar Ghosh petition number 6 was turned down by the Panchayat and Rural Development Department, observing that the Pradhan of Golar Gram Panchayat observing as follows. The report submitted by the Paschim Medinipur Jila Parishad also indicates that the engagement of the petitioners were not made upon formal approval for engagement either from the Health and Family Welfare Department or the Panchayat rural departments. Thus, the order impugned of the Panchayat and Rural Department dismissing the prayer of petition number 6 does not call for interference. The prayer for appointment of the petitioners and their regularizations are also turned down. The writ petition being number WPA such and such is dismissed. Sorry, could not help. Yes, next. What's petitioner? Your fault?
Statement.
What? Your 7 and 8, who is the respondent number 7 and 8? None appears on behalf of the petitioner, nor any accommodation has been sought for. It is also found that not any accommodation sought for. Respondent number 5 and the state are represented. In view of the above, the writ petition is dismissed for default. Dismissed default for no? Dismissed for default. Or currently the application is 48. Advocate for the deficit court fees of government deposit department. Following the matter is returned, we are dependent upon if the report in terms of deficit court fees factor has been received by this department. Yes. Yes. State is the only respondent.
The second round of
Are appointed through a selection process created by the Panchayat and Rural Development Department. Kindly have a look only one paragraph of it.
56.
56. It's the program of NREG centers, mainly
Bulk of the
around
book is the implementation.
the Gram Panchayats. The bulk of the work associated with the implementation of the NREGP is done at that level.
it is felt necessary to strengthen the administration capabilities of the Gram Panchayat by way of additional manpower support to those GPs where the volume of work has exceeded certain limit. It has therefore been decided that one Gram Rozgar Sevak will be engaged on contract basis in every Gram Panchayat, not in for a specific code, in every Gram Panchayat, which has generated at least 15,000 persons day in a continuous period of 3 months.
This will be for period of 3 months they will be engaged.
No, that was the cutoff. Continuous at least 300% days in a continuous period of 3 months, one Gram Rozgar Sevak. Since the project was launched by the central government,
Does it design the 1 gram GRS will be engaged on contract in every Gram Panchayat?
next paragraph, however, in some of such Gram
Oh.
Panchayat, there may have one job assistant, including those who are working as secretary GP, whose service is available for taking up
In
additional work.
1 gram, there has to be 15,000 persons working for a period of 3 months.
No, but when there are 15,000 manpower for every 3 months is required one GRS. Till today, they have been appointed in terms of the notification issued in the year 2007, and till today they have been rendering as Gram Rozgar Sevak appointed in respective Gram Panchayat. Their term at service has been salary has been enhanced. Thereafter, period of leave, casual leave, benefit of leave has already been extended. But since the in terms of the notification issued in the year 2016, the minimum remuneration has not been enhanced. Petitioner made a representation. Till date, no result. Therefore, in terms of the notification issued in the year 2019, for the security of tenure of service and the minimum remuneration, again they made representation, and that has yielded no result. Thereafter, my lord, the first round of repetition that was, kindly have a look at page 112. The petition filed by the petitioners has been disposed of. Relevant paragraph, my lord, page 114, third paragraph. At the learned advocate and peruse the materials on record, peruse the materials on record placed on record. Record reveal that the petitioners were appointed as Gram Rozgar Sevak through a selection process under the MRGA scheme, and the government has reviewed the service conditions of casual deliberated contractual workers from time to time and extended the benefit of revision, consolidated monthly remuneration, and security of tenure of service. Records postulates that in 2019 the petitioners made representation before the concerned respondents, but the representation is still awaiting decision of the respondents. Having considered the factual conspect of the matter and having been anxious consideration to the submission made on behalf of the parties, the Commissioner, Government of West Bengal, Panchayat and Rural Development Department is directed to consider and dispose of the representation of the petitioners in accordance with law within 4 weeks from the date of communication of the order. The Commissioner shall decide whether or not the benefit as referred in the memoranda dated 25th February 2016 and 8th February 29 can be extended in favor of the writ petitioners. My last paragraph of that page, page 115. If the representation is decided in favor of the writ petitioners, the Commissioner shall take up next course of follow-up actions to extend the benefit as referred in the memoranda dated 25th January 2016 and 8th February 2019 in favor of the petitioner within 4 weeks thereafter, and if it is decided against the petitioner, the Commissioner shall pass a reasoned order and communicate the same to the petitioner within 2 weeks from the date of such decision. I will kindly have a look only two notifications. Two notifications. Well, only two notifications. Well, kindly have a look. Page 10. This is a notification issued on 25th of February 2016 by the Finance Department.
105.
Finance Department.
105. 105.
Page 105. In this department, number 9008 FP 16 September 2011, it was decided to allow appropriate emoluments, security of tenure, and certain terminal benefits to the casual, daily rated, contractual workers subject to fulfillment of the conditions therein. The matter regarding improvement of monthly remuneration, annual increase, medical facility, leave, and other benefits, as well as review of the condition of engagement were under active consideration of the government for some time past. Now, after careful consideration of the matter, the governor has been pleased to decide to revise the benefits as follows. All contractual, casual, daily rated workers shall continue to be engagement up to the age of 60 years. Engagement of contractual, casual, daily rated worker shall not be terminated except as prescribed in the above referred memo. 2. Consolidated monthly remuneration of contractual, casual, daily rated workers will be as follows. Group D. Petitioner belong to Group C. Less than 5 years, entitled 11,500. Thereafter 5 to 15 and more than 20 years, 22,500. This was the notification issued by the Finance Department. Thereafter, my lord, kindly have a look. Such benefit has been extended. Next page at page 107.
GRS. They are Group C.
My lord,
Group C.
Group C. Ramrojkar Sevak, Group C. Next 107. Under the department such and such, my lord, 3100 contractual employees were engaged against sanctioned Group D vacancies, which were lying vacant for a long time. The engagement period of these contractual employees has been extended from time to time. The last such extension has been done up to the month of November 2018 by memo dated 24th of November 2015. Third paragraph. After careful consideration, second paragraph, very important. The terms and condition of engagement and other benefits of all other contractual casual workers in the state is governed by the Finance Department memo dated 16 September 2011, which was last revised dated by memo dated 25th of February 2016. Now a clarification has been sought for on the entitlement of the remuneration and other service benefits as envisaged in the memo dated 25th of February 2016 in respect of 3100 contractual employees, Group D employees. So this has been allowed for the Group D employees. Even then the Group C employees, those who have been selected through a selection process initiated by the Panchayat and Rural Development Department, they were not, benefit has not been extended to them. Well, the next circular, page 109. 105.
But this is not applicable in your case.
For all.
No, this is for Group D.
2017 for Group D.
Uh,
105 for all. Group C and Group D. And page 109, dated 8 February 2019.
You will be if you are favored with the order, then you will get the benefit of 105, page 105. Which notification are you pressing for? You'll be considered under which notification?
Was, my lord,
105.
109 now. This is the latest notification.
109.
8 February 2019. The question of further improvement of condition of service of casual, daily rated contractual workers engaged in various government establishment in terms of the memo dated 16 September 2011 has been under active consideration of the government for some time past. After careful consideration of the matter, the undersigned is directed by order of the governor to say that the governor has been pleased to decide as follows. With effect from 1st February 2019, the consolidated remuneration of the above categories of workers will be revised as follows. Group C, less than 5 years, minimum remuneration 13,500. Less than 5 years. 5 to 10 years, 15,500. Page 109. 2. With effect from 1st February 29, such workers on attaining the age of 60 years will be entitled to one-time terminal benefit of 3 lakhs in place of existing 2 lakhs. The above categories of Group D who possess educational Madhyamik pass, I am not on that. 10 year of engagement, yearly enhancement of remuneration, medical facilities, leave facility of such workers shall be guided by the provision dated 25th February 2016, which is at page 105. Thereafter, my lord, in compliance with the direction, the order was passed, which is under challenge before my lord, one-page order, or at page 120. This is regarding writ petition being number such and such in the matter of Sattoki Chowli and others versus State of West Bengal others, filed in the Honorable High Court at Calcutta, hereinafter referred to as the Honorable Court. It is pertinent to mention here that the Honorable Justice Parthasarathi Chatterjee, by solemn order dated, has been pleased to dispose of the said writ petition by directing the Commissioner Panchayat, Rural and Development Government of West Bengal to consider and dispose of the representation of the petitioner in accordance with law, and to decide whether or not the benefit referred in the memorandum dated memorandum number 1107 finance dated 25th February 2016 and 1033 dated 8th February 2019 can be extended in favor of the writ petitioner. In compliance with the solemn order passed by the Honorable Justice Parthasarathi Chatterjee, notice was issued to the concerned petitioner duly nominated by other writ petitioner as envisaged in the solemn order for hearing. Accordingly, 2 writ petitioners, viz. Sri Shaunak De and Sattoki Chowli, appeared before the undersigned and attended the hearing. Heard the petitioners at length and all the relevant documents in connection with the instant matter, including the representation and the writ petition, have been carefully perused. It appears therefrom that the petitioner want to avail the benefit as refers to memoranda dated 25th February 2016 and 8th February 2019 issued by the Finance Department, Government of West Bengal. It also appears that the said 2 memoranda emanate from the memorandum dated 16 September 2011 issued by the Finance Department. Now, if we have a look at the mode of engagement of Gram Rozgar Sevak as envisaged in the order dated 19 September, it can be seen that the Gram Rozgar Sevaks were engaged purely on contractual basis under a specific project, not against any sanctioned post, and their engagement will be renewed from time to time. But appears from the paragraph 10 of the memorandum dated 16 September that the provision of this order will not be applicable where contractual engagement has been made without sanction post and for any specific project for a temporary period of maximum 6 years or finishing the project whichever is earlier. Order. In the aforesaid facts and circumstances and after careful consideration of the entire matter in detail, including the representation and other relevant documents, it is very much clear that the provision of the memorandum dated 16 September 2011 is not applicable to the petitioners, and as such, the subsequent memorandum dated 25th February 2016 and 8th February 2019, which is originate from the memorandum dated 16 September 2011 issued by the Finance Department, is also not applicable to the petitioner. As such, the claim of the petitioners cannot be entertained. as they are not eligible to avail the benefits of it. My lord, kindly I have already placed before my lord the notification which was issued by the Panchayat and Rural Development Department in the year 2007. But kindly have a look. 1 second, my lord. Page 56. Page 56. It has been clearly mentioned in the order 21st November 2007. It is felt necessary to strengthen the administration capabilities of the Gram Panchayat by way of additional manpower support to those Gram Panchayat where volume of work has exceeded certain limit. Volume of work exceeded certain limits. According to the requirement of the Gram Panchayat, one Gram Rozgar Sevak will be appointed. They have not been engaged against a specific term. Not been engaged against a specific term. Therefore, however, in some such there may have one job assistant whose service is available for taking up additional workload. No GRS will be engaged on those Gram Panchayat. The GRS will be paid a consolidated monthly remuneration of rupees such and such out of available administrative cost, which will be allotted separately. Gram Rozgar Sevaks will be selected based on merit. No backdoor appointment. Not at the sweet will of any departmental officers. They will be selected based on merits. The candidates should have passed higher secondary in science stream so that they could be easily trained to take measurement for simple earthwork, which will be reduced burden of Nirman Soil at least 55% from science stream. Candidates who have passed higher secondary examination from any board of the state will be preferred. The candidate must have at least 6 months training on computer application. And kindly, my lord, thereafter the notification that was issued, employment notification, at page 60.
Page
Advertisement of
57. Page 57.
Right.
It says that the renewal can be made for one term, that is 1 year. If after the period of contract is over, the renewal of contract for 1 year may be allowed, subject to satisfactory service.
Well, after the period of contract is over, the renewal of the contract for 1 more year may be allowed,
Yes.
subject to satisfactory service rendered by the GRS. Only if at least 15,000 persons days have been created during next 3 consecutive months during such and such. My lord,
No, do you read that?
their service are already been renewed till today.
How?
Continuous service. The renewal order has been issued by the department.
How this is being renewed?
Renewed, my lord. I have already annexed the document.
Who is for the state?
I have served notice of Mr. Fisher, which was received on 23rd of the matter was last heard on by my lord on 22nd of my lord was pleased to direct me to serve notice of the
Okay. Is a copy of the notice? Give the notice. Where is that extension of this renewal?
page 75. The block development, my lord, have got it, page 75. The block development officer and program officer Joynagar block South 20 has extended the engagement of skilled technical person, Gram Rejgar Sebok, and village level entrepreneur working in different Gram Panchayat under MGA NER of this development block mentioned below up to 31st March 2019. This is one. Next page, my lord, this was also issued by Joynagar Development Block. Joynagar 2 Development Block. Page 77. Engagement of the following GRA STP GLE working in various Gram Panchayat under
And this
MPREGA of this block mentioned below have been duly extended up to 31st March 2020 as per usual terms and condition. Kulpi South 24 Pargona.
also, এবার একবার notice দিক।
The tenure of service of the daily rated worker.
ওই যে আছে শীর্ষণ পদে সিনিয়র অ্যাডভোকেট না শীর্ষণে দিয়েছে কিন্তু শীর্ষণ থেকে কোনো অ্যাপয়েন্টমেন্টই পাচ্ছি না। শীর্ষণে যদি ওখানে না অ্যাপয়েন্টেড থাকে তো ওতে আপিল করবে না এখন। Mr. Indranath Mitro, learned advocate for the petitioner, submits that the petitioners were appointed as Gram Rojgar Sevak GRS within bracket GRS on contractual basis in different Gram Panchayats under the for implementation of ANREGP. Which year this engagement was done, in which year? In the year
After 2007, my lord, first, that is the thumb joining
in,
report I
in
have already
2007.
at page
The
53.
petitioner in the present writ petition has sought for revision of the remuneration in terms of
63,
memorandum number 1033-F within bracket P2 dated 8 February 2019. This is the last one. 1033 is the last one. 109.
109. Thereafter, in the month of March 2024, another notification was also.
The petitioners earlier filed a writ petition wherein direction was issued for considering the representation of the petitioner. However, the same has been rejected by the Commissioner MGNRE GA7 GA. Video order dated 17th October 2023. Being agreed by such order, the petitioner has preferred the present writ petition. Notification টা ওখানে বাদ দিয়ে দিন তো for revision. for revision of the remuneration in terms of memorandum of the government of West Bengal. None appears on behalf of the, despite notice, none appears on behalf of the state. Mr. Bandopadhyay has been engaged in this case.
As I have been told from the GP office. Mr.
But who
Bandyopadhyay
will ascertain this?
assured me that he will appear on the list. Whenever I meet with him, I
The
say,
presence of the state will be necessary for deciding this. What to do? He has not come today.
yes, come to the council, senior standing council of the state.
Okay. Might be busy.
Or kindly
But-
keep it tomorrow. I will go to the office of Mr. Bandyopadhyay and I will.
No. What do you got to me? 19th কি টপে আছে দেখো তো মানডেতে or এই উইকে ডে আফটার টুমরো এটা যে অর্ডারটা আসার একটা টাইম থাকবে তো তাহলে আমি কি এতে করবো থার্সডেতে করবো আছে 15th ওইটা মোশনে আছে তো কবে আসবে এটা কাল পরশু আসবে এটা 24 এর মোশন তো কালকে আসবে না পরশু আসবে নেক্সট উইকে কবে দেবো 19th 20th টপে আসবে ঠিক আছে release this matter on 20th May under the heading motion. Petition is directed to serve a fresh notice upon the learned advocate for the state. 20th.
Have another notice to Mr.
Yes, give a notice.
20th at the top.
Top. $100?
I will finish my, I think 2-3 judgments I have.
215.
I was in fact in the verge of conclusion of my.
State Commission, Election Commission to go.
Like arguing this matter, keeping in mind that there are numbers of matters in which point of maintainability was taken by the Election Commission as well as the state. So far, my repetition. For this matter is concerned, last week I have shown to your lordships my prayers. First prayer was upload the affidavits because I made the submission by referring the notification that was issued by the Election Commission. The Election Commission was supposed to upload affidavit taken from the respective candidates. So my first prayer was upload the affidavits so that all the electors can exercise their adult franchise after being informed. Now, I'm just citing this judgment. This is 2014 SCC 189. This is the basis of the notification that was issued by the Election Commission.
Which paragraph?
But I'll be referring paragraph 11 first. In the background of paragraph 2, that was the object to maintain purity of the election. Petition was filed. Paragraph 11, court was considering if the affidavits left blank whether nomination should be cancelled or not. Paragraph 22. From this article 19(1)(a) has been considered, then paragraph 22, last three lines, I'm just trying to. The citizen are required to have the necessary information at the time of filing nomination paper in order to make a choice of their voting. So this is directly connected with the purity of election. When a candidate files an affidavit with blank particulars, it renders the affidavit itself nugatory.
Now you have got a copy of the affidavit which was
Till date, it was not uploaded. Nobody knows what is there in the affidavit. Nobody knows
Oh.
about the candidates.
how this will come to your aid, because you cannot right now assume or presume that it is blank or it has been filled up.
No. I say that even if it was uploaded with a blank affidavit, the nomination had to be cancelled. Judgment of Supreme Court. Then if it is not uploaded at all, then you have no choice. No electors know about the candidates. The object was that the site must be informed. That is my
Paper
submission.
down. Paper.
I am on paragraph 22. Citizens' right to know before exercising her voting right.
Yes.
And my fourth prayer is that investigate into the conduct of the election commission. Now that connect this with this submission, that my facts of the case is until 29th June 2023, the website shown that the candidate is a OBC candidate, and the seat is reserved for the. I'm sorry, the candidate is a general category candidate. The schedule after that 15th June was the date of nomination, making nomination. 17th June for scrutiny. 20th June for withdrawal of candidate. 8th July was the election. Therefore, whatever correction, addition, alteration can be made on the day of scrutiny, that is on 17th June 2023. After that, election commission has nothing to do with anything except holding election, the poll. Admittedly, from the records, I can demonstrate that on 7th until 29th June 2023.
Give the date once again.
That 15th June was the nomination date.
15 June 23.
23. 17th was for scrutiny.
Slowly. Date of nomination. 17th is scrutiny.
28th is the withdrawal of candidature. And 8th was poll. But by citing page 27, the order of the State Election Commission,
Yes.
I say that I being an elector, I was deprived of being informed. So since I filed the writ petition prior to poll, so my prayer was upload in the website. So occasion was there because they were served with this writ petition prior to the date of poll. They didn't exercise their own power or to implement this order, their own order, which vitiates the election process itself. And particularly with this allegation. Now at page 32, 33, all are complaints made to the authorities. 33 is to SDO.
Page 30.
31, 32, and 33. 32, we have sent this complaint through WhatsApp. And 31 and 32, directly to the authorities, personal service. And all this communication was made prior to election. There was no delay.
Yes.
Now that now that the post independence, all judgments relating to election, the immunity was given to the Election Commission by constitution as well as by judgments. The expectation was that the Election Commission will act independently and fairly. But in 2023, Supreme Court has held otherwise. And considering all prior judgments, I'll be referring only the relevant paragraphs, paragraph 200.
কোনটা একজন সেট করছিস কোনটা কোনটা এটা ইলেকশন অফ দ্য প্রধান হ্যাঁ হ্যাঁ হ্যাঁ
Yes, choice page 1. Page 1.
Which paragraph?
Paragraph 200. This speaks of plenary power of the Election Commission. And similar power was given so far is State Election Commission is concerned also under section under article 243K. This article 324 is similar to Article 243K of that. Similar power is given to the West Bengal, the State Election Commission. But from the top left, first, second, third, fourth, fifth line, the power of the commission is also subject to norms of fairness. It cannot act arbitrarily. The action cannot be mala fide. The Article 324 governs in the matters not covered by legislation. Being high functionary who is expected to function fairly and legally, if it does otherwise, the court can veto the illegal action. Statement at paragraph 213.
Yes.
That first 3-4 line, undoubtedly the election commission is duty bound to act in a free, fair and legal manner. It must observe the provision of the constitution, abide by the direction of the court. So I have cited direction of the court of Supreme Court of 2014. And the constitution. The same being done, it can draw upon a nearly infinite reservoir of power once the poll is notified, which again is a call to be taken by the election commission itself, and indeed capable of being misused and subject to of considerable controversy if bias or subservience of to the parts that is betrayed. It assumes unusual power. It lies across the governments over the length and breadth of the country. Officers of the government who comes under its charge become the subject of superintendence of the commission. Therefore, election commission cannot say that it is not done by me. Complaint was made to the authorities who was the election officer at the relevant point of time. Now, at paragraph 214. Only for this proposition that all officers are election officers for this paragraph. Then 214 is for the proposition that election dispute may not be the just solution.
Yes.
Number 214 is for the proposition that election dispute may not be the just solution. And keeping in mind, the election commission had the occasion, could have cured the immediately after receipt of my complaint, upload the affidavits and all this. Paragraph 214, it is in this scenario, we bear in mind that when a decision is taken in the process of holding a poll, the subject to the proceedings which are initiated in the courts which conduce to the effective holding of the poll, any proceedings which seeks to bring the election process under a shadow of is tabooed. The significance of this aspect is that it adds to the enormity of the powers and responsibilities of the election commission, awarding to the outcome of the poll to question the election before the tribunal may result in many illegal, unfair and malafide decisions by the election commission passing muster for the day. Once the election results are out, the matter is largely reduced to a fait accompli. In fact, many a time an omission or a delay in taking decision can itself be fatal to the holding of free and fair election. If the relief vouchsafing by itself provide a just solution to conduct the election in an illegal, malafide or unfair manner. Now, my lord, here complaint was made, writ petition was served.
Yes.
Then, my lord, I'm not reading paragraph 218, 19 and 20. This speaks of, my lord, fundamental rights and independent of the election commission.
মাথায় আছে। Yes.
Now, my lord, paragraph 218. On 18, 19 and 20. Equality, I'm just reading 20. Equality, the sterling qualities which we have described, which must be possessed by the election commission, are indispensable for an unquestionable adherence to the guarantee of equality in Article 14. In wide spectrum of powers, if the election commission exercise them unfairly or illegally, as much as it refuses to exercise, when such exercise becomes a duty, it has a telling and chilling effect on the fortune of the political parties. Inequality in the matter of treatment of political parties who are otherwise similarly circumstances and unquestionably breaches the mandate of Article 14. Therefore, the next page, any action or omission by the election commission in holding the poll which treats the political parties with an uneven hand, and what is more, in an unfair or arbitrary manner, would be anathema to the mandate of Article 14, and therefore cause its breach. Here, the candidate whose category was changed is belong to the ruling political party.
Till the poll is being conducted, if the rules and the orders is not followed by a state election commission, what is the recourse left to the candidate who is challenging such action of the state? Is it filing of a writ petition? Is the court session of that during that period? Since in this case, it started from June 2023, the polling was on 8th July. In between this period, you have filed on 4th July, you have filed the writ petition. What was the other recourse open to, since that was indicated by you that the declaration of the affidavit was not uploaded? If the state election commission does not follow it, who is the other authority upon which the people can lodge a complaint? That was done.
It is the election commission who have informed.
No, state has not followed. Is state being, any appeal is being preferred before the chief election commission?
It is a state election commission who conducts the Panchayat elections or any election of the local body.
Yes.
As like the election commission of India in case of assembly and.
But all the state elections commission are under the election commission of India? No?
Independent body.
Independent. Okay.
constitutional body.
So this was the only recourse left to the petitioner to file a writ petition.
There is no remedy. The remedy available in the statute, so far Panchayat election is concerned.
Once the notification is being
Mr. Samim, let him complete it. You will make your submission. Yes, this is the only recourse left.
My difficulty is that in West Bengal, whenever we fights an election commission was supposed to be independent. But whenever we try to contest by the state and election commission merges together, it does not remain independent. That's the whole difficulty we file the writ petition. Namlat, here
No.
that until the election result is declared, I have no remedy, statutory remedy available.
Okay.
Therefore, writ petition is the only recourse. Now, after the poll is over, again points come whether I could have filed a writ election suit, election petition or not. But I have to address that also. And even if I can institute a election petition, what are the relief that can be granted by the election tribunal? Whether the reliefs I have sought for in my writ petition is available in the election petition or not. That I'll argue. Now, before that, paragraph 249. '49, 250 and 51. These are all observation. So far, independence of the election commission is concerned.
Stop here. Did बोलूं? You have filed your written notes of?
I am yet to file.
But you submitted before the earlier bench, you will be filing.
They have filed.
No. No, after they have filed, you have made a submission before the court that you will be filing.
I have not filed yet.
Please file the same on the next date and conclude your argument. বলো তো?
শেষ করবি।
22 তারিখ 22nd. Conclude that.
It's from 2 p.m. because my understanding will take again time and
2 p.m. there are motion matters. That is the difficulty in the returnable motion. On 22nd. On 22nd May. On 22nd May, this will come up. The next week itself, there will need to change. Chalo. Or Mr. Shamim Ahmed, an advocate for the petitioner, due to proceeding the hearing could not be concluded, this matter on 22nd May. Conclude on it, please. I think no, on 22nd May. You will conclude. No matter. Please, on that day you conclude. Yes. Gauthuda, specially jeta ache.
Item number 241.
No. দেখো বলে দাও কালকে যদি হয় কালকে নিয়ে নাও।
Before he begins, I had referred to these books of jurists
I'm handing them. Your Lordship had desired that I hand them.
With regard to the statutory provision that my last friend has, senior friend has referred, I have extensively dealt with Milord, each and every Milord rules that has been pointed out by them, why it's not necessary, why this is not German with regard to the subject matter of the petition. I have already Milord canvassed before your Lordship, including my exception to the report. And Milord, I have also Milord shown before your Lordship that with regard to that amendment part of regularization, what is the position of law as on today, who can do that, and the process by virtue of which it can be undergone. So under any stretch of imagination, Milord, whatever
Rule 32.2.
Rule 32.2. And also, Milord, yes, that is the amended provision. Milord, there, Milord, I paused, Milord, at that juncture, Milord, since the time of the court was not permitted. Now, Milord, apart from these two, Milord, my learned senior friend has taken, Milord, two other points. Mainly, he canvassed many things with regard to the railway circular, whether it's a mandate of law, whether it's a statutory effect. Milord, even if I take it from my learned senior friends that this is not something which called to be a statutory mandate, but it is mere a guideline. Milord, I will try to persuade before your Lordship, the Supreme Court also, in dealing with this kind of unauthorized cases, are taking consideration of what were the guidelines that has been framed for the purpose of maintaining this construction to be done. Like the fire department and other local authorities, they have framed. No, that is though not be a statutory form, but while granting that sanction, it is, I am saying, not about the private respondent. It is the duty of the municipality. Today, suppose a G plus multi-storage building, your Lordship knows that the fire department says if it is a multi-storage building, then fire safety measures are mandated. One of the measures is that there can be a building where the fire safety authority can say that there should be an external staircase for the purpose of evacuation in case of any fire emergency. But there are a number of buildings standing at Kolkata also, where these measures have. So now, the Supreme Court is taking aid of. While granting of sanction, you have to ascertain from the local authorities that their mandated guidelines whether should be followed or not. Today, your Lordship is looking at this Honorable Court is taking its rooftop. This rooftop construction, if the municipality said it is within our bounded discretion as per the statute, we are the authority who can give sanction. We are not duty bound to send it for recognition of any other authority. So what the fire emergency when it happens, what the fire authority is saying that due to this construction, the ladder systems are not being affixed. So entire thing goes frustrated. So now everything is being done by municipalities. This position has been taken care of by one of the Supreme Court. This is one aspect wherein the railway authority has also shown before your Lordship in case of a BLLRO also. While granting sanction in one of the matter, this Honorable Court directed in a content matter, ultimately this was sent through the Railways Authority for grant of NOC. So I am not saying it is the duty of the private respondent in this juncture. Otherwise, the unauthorized construction part, the misrepresentation in holding, in obtaining sanction, yes, they are duty bound. But in this case, it is a statutory duty for prior to grant of sanction by the municipality also to adhere and to ensure that other local authorities, whatever the guideline that has been framed, whether that has been complied with or not.
Yes.
But I am wife quoted judgment below the 2021 volume 10 SCC, page 1. It's super tech, my learned senior friend is quite aware, Paragraph number. The para 160 and 164, I'm placing reliance of uh, 160.
Yes.
The page 86 of the paragraph 160. From commencement of to completion, the process of construction by developers is regulated within the framework of law. The regulatory framework encompasses all stages of construction, including allocation of land, sanction of plan for construction, regulation of structural integrity of the structure under construction, obtaining clearance from different departments. Lord, the example was given: fire, garden, sewage, etc. So, Lord, it's not about only with regard to the statutory mandate of the municipality, which my learned senior friend was suggesting. The Supreme Court also taken care that while granting sanction and from making construction till the completion, it has to be undergone under a supervision that all the mandate and guideline of the other local authorities are also fulfilled.
Yes.
(164), Milord, I am just now placing before your lordship for the wasting of time of the court. It also aid of the other judgment, which also said this. Fine. Uh, 2021 volume 10.
Yes.
Another point my learned senior friend has placed: how I am prejudiced and what is my locus. This, Lord, for this, Lord, recently this honorable court, Lord, this is not unreported. That's why I have a copy.
I'll have to reply to this. I'll have to reply to this.
But it's on point of law. Since my learned friend has taken this point with regard to my locus and how I prejudice for filing or maintaining this writ petition, this I could not able to answer at the first instance of my submission, because my learned senior friend has taken this point after giving his answer. So I have to answer this legal point, at least on reply. I have not gone into any of the factual aspect of the matter. Yes, my learned senior friend definitely do have a right of reply. Yes, I can. WPA 1631. WPA 161 of 2022. Here, the Deepak Mukherjee, starting from Deepak Mukherjee to the super tech, everything has been considered. Kindly takes up internal page 11 of the judgment. I am not troubling regarding the quoting of the Supreme Court judgment. The relevant portion has been quoted. Now, kindly takes up page 11.
Yes.
Thus, the contention of Mr. Bhattacharya with regard to the locus of the petitioner is not accepted for the reasons stated herein. This court is of the opinion that this proceeding shall be restricted to the failure of the corporation to take cognizance of the complaint lodged by the petitioner petitioners. The Waqf board, the decision of Mutwali to develop. May I? Yes. May I just give me one? Kindly take up page 3. Answer. Page 3. That is the penultimate paragraph. Had the learned advocate, not the second paragraph, had the learned advocate for the respective parties, point of locus is taken up first. The petitioner alleges that they are used to offer their prayers which has been demolished and unauthorized construction have been allegedly made. It is a matter of practice that a court invokes the writ jurisdiction in cases where a legal wrong or legal injury is caused. Kindly takes up. Unauthorized construction are against public interest. They affect the environment and the right of citizen to live in a planned and organized city. Moreover, silence of the corporation amounts to perpetuation of such legal wrong. The corporation is maintaining silence on receiving such complaints, have failed to exercise their jurisdiction under the law, and all citizens in the opinion of the court who are taxpayers to the corporation can bring such illegalities to the notice of the writ court and pray for a direction upon the corporation to discharge its duties in accordance with law. It is the bounden duty of the all follows the regulatory laws under the making construction, even their private land. Now, the super tech, the provision is being quoted. I am not troubling your lordship regarding that. Paragraph 159 also quoted. Thereafter, another judgment of the coordinate bench, where also the point of locus was being taken, my lord, in WPA 740. That is at page 7. That has been, as your lordship got it, my lord. Same point was taken, and my lord, the division bench has taken care of that aspect. Thereafter, again, Supertech 162 paragraph is being quoted, Deepak Mukherjee quoted, and ultimately, my lord, the page 11, the contention with regard to the locus is being negated. So, my lord, today, the law as on day that has been declared, this is a wrong.
Yes.
The perpetual wrong. Any taxpayer who is not just giving an information to the, now it is the duty of the municipality to look into it. Today, my lord, the law is, there is no more that a locus of a person is important while considering a case of unauthorized construction. Because today, what your lordship is deciding, that whether the municipality is doing their statutory work, because they are the person, they are the authority who is taking care of these things. Whoever may be complaint, this can be done suo moto by the municipality. Rather, this is that is their duty to do it. They have not done. So, a person has approached, made a complaint. And the other thing, here in this case, it's not that I am a third party residing separately elsewhere. I am in the locality, rather I am the neighbor. So, no more, my senior friend can say regarding my locus or special equity or prejudice. How I am prejudiced, I am prejudiced. But still, for the purpose of proposition of law, I am citing this judgment that whether I am prejudiced or not, whether I am in locality or not, today no more that is factor to be considered while deciding a case of unauthorized construction. So, my lord, I am resting my case by saying that I have demonstrated before your lordship how the fraud has been perpetrated while obtaining sanction for invocation of provision of section 217. 218, my lord, I have demonstrated rule 50, what is the mandate of law, what is the present position as per the report of the municipality, which is beyond the law or prescription of rule 50. Whatever, my lord, the provision of law, that is the rules from the rules my learned senior friends have relied upon, that is not any to their benefit. The subsequent amendment is also neither here nor there. And at last, my lord, these 2 points of locus and so, my lord, this is my lord submission.
Next. You have concluded. Because you're an advocate for the petition. Because he will also be making some submissions.
Let him finish, then I'll just make a very short reply to his. New judgment was cited. I'll have to distinguish actually. Will it be possible?
Don't know. কালকে হবে না মনে থেকে Mr. Tanmuyan, advocate for the petitioner in WPA. You are 10868.
10868.
Of 22 includes his argument. Advocate for the petitioner in WPA 29103 of 2023 seeks accommodation to make his replies. বলো ডেট ওইগুলো হবে না petition আগে দিয়ে দাও শেষ করে গোটা হবে 21st না 4 PM হবে না ওদিন একটু এগিয়ে দাও 3:30 হয়
তুমি কতক্ষণ তোমার টাইম নেবে
4 PM করে দাও 4 PM if we start at 4 PM happen 21st
10
Please go ahead. টপে থাকবে এটা স্পেশালি অ্যাসাইন টপে থাকবে 4 PM
deeply obliged.
I'm so grateful.